video, I want to step you through a decision that was handed down by the Federal Family Court in July 2025 about the asset protection of family trusts and discretionary trusts in family law proceedings. So the decision is Caldwell and Caldwell, and it concerns a husband and wife who were married for 30 years. They have significant family trusts and companies in their group. And in this case, the wife was seeking a declaration. The wife was seeking a declaration that the assets in the trusts and companies were properties of the parties and divisible property. So we know that when it comes to assets in trusts, that the assets will generally always be considered a resource of one or both of the parties to the relationship. It's the question of whether they are property and therefore divisible property, able to be withdrawn from the trusts and distributed to one of the parties, that is usually in contention, and that we rely on discretionary trusts to try to protect those assets. So let me talk you through the facts. Here we had a 30-year marriage between the husband and the wife. Now they separated around 2022 and divorced in 2023. And that time period is actually really relevant to consider. So put that in your head. Now they actually had significant assets outside of the trusts and companies in question, around 16 to 22 million. Now, what I think about this decision is so fascinating is that it's a high net wealth decision. We've got a big family group and quite a few trusts. So I love it when we get decisions like this where we can really see how the court is applying the principles and stress testing the protection of the trust. So in this decision, we have a number of trusts and companies, I'll show you in a moment, that were established by the husband's father, and there were assets contributed into those trusts and companies or created and ultimately contributed into them by the husband's father, grandfather, and great-grandfather, including a business that the husband's great-grandfather created in the early 1900s. So big intergenerational wealth assets here. So the wife was seeking the declaration under Section 79 of the Family Law Act that the trusts and their assets were property of the parties to the marriage. Now, the husband does control or have some control of the assets, but importantly, he only received control of those assets on his father's death in 2022. So let's have a look at the family tree so we know who we're talking about. So we've got the husband and the wife in teal here. Now, the husband's father has passed away in 2022, the same year as the relationship broke down and the husband and the wife separated. We have got the husband's mother, Mrs. K, still living. I'll just highlight the husband's father is generally referred to as Mr. K in the judgment, so we'll call him that. There's 3 siblings of the husband, and then the husband and the wife themselves have got 3 adult children in their late 20s and 30s, and most particularly 2 sons, G and H. Now, I want to step you through the structure of the trusts and companies. And this is what I've been able to piece together based on reading the judgment. Obviously, we don't have the full picture and quite a lot of the personal information was redacted or changed, but this is my understanding of the group dynamic. So probably the B family trust is the main one. This structure seems to operate a retail empire, and the retail trading businesses are these 4 Caldwell Proprietary Limited, R, S, and T Proprietary Limited. And we've got a series of holding companies. But if we kind of just focus on above the line with these 3 trusts, they all operated and structured in a similar way. So under the husband-father's will, so husband's father is called Mr. K. So under his will, he previously owned like most of the shares in the trustee companies. He left them to the husband and the husband's 2 sons as joint tenants. So, like one A class share, the A class shares have all the voting rights, was left to the husband and the two sons. So the husband, the testator's son and grandchildren as joint tenants. Um, in the constitutions for the companies, they say that where the shares are held jointly, the first person in the register is the one who like gets to vote. So the husband is the person, so he's sort of has the main use of that voting share. There's also ordinary shares that have no voting rights. You'll see in some of them, the husband's mum, Mrs. K, has some ordinary non-voting shares. And then in terms of directors for C Proprietary Limited and D Proprietary Limited, those two corporate trustees, it's the husband and his two sons. And then for B Proprietary Limited, that corporate trustee, it's the husband's sister, Mrs. L, and then the husband's two sons. So husband's not even a director of B, and he's one of three directors for C and D Proprietary Limited. Interestingly, as I believe with the appointor principal role, again, it's the husband and his two sons, H and G, but the deed was updated so that the husband is almost a super appointor in the sense that he can actually unilaterally remove H and G as appointors um, without any giving them any reason. So he's sort of got like an extra role where he can change up who the appointors are. So interesting structure where there's shared control, but the husband is still sort of given extra rights. So all the trusts are discretionary trusts, except for I believe the E trust, which owns a property. I think it's a fixed trust, but we didn't get a lot of detail on that. Um, The husband has never received a distribution from the trust, but he is a beneficiary of the trust. To our knowledge, the wife has never received a distribution from the trust, and she was actually excluded as a beneficiary during the marriage by the husband's father between 2019 and 2021. There was a series of variations. So, husband's father, before a bit before his death, bit before the relationship breakdown, updated the deeds to basically say there was already an existing definition of excluded beneficiaries, and they excluded a person who was not a direct lineal descendant of Mr. K, who was the husband's father. And some of them, they're a little bit different, but some of them do also include companies whose directors and shareholders are not direct lineal descendants of Mr. K, and same with trusts. Um, the change of appointer from Mr. K to the husband and his two sons, G and H, happened as part of the succession plan when Mr. K died as well. So we've had that change happening. So let's have a look at Mr. K's will, the husband's father's will. So he died 2022, left the shares, and he actually made this direction in his codicil, which I thought, sorry, he made a codicil to his will to include this direction in his will. So, really just emphasizing the intention of my father, being the husband's grandfather, is that the business remains within the family. The overall purpose and intent is that on my demise, it's to go to the control of the husband, Mr. G and H, so to the two sons, all the survivors of them acting jointly, and basically they have the privilege and opportunity to take the business into the future. So we've got big intergenerational wealth transfer vibes coming from this clause in the will. Now, I want to just take a break. So this is a slide from my course, Testamentary Trusts, the Essential Guide for Australian Lawyers, in the Asset Protection module. So we've talked about Cannon and Spry. You're probably all familiar with that. It's like the landmark family law case attacking discretionary trusts. And there's been a series of cases, a smattering of cases following Cannon and Spry where it's been applied in different ways. And different factual scenarios have drawn out principles. So the key principles from Kennan and Spry, but also the cases that have followed Kennan and Spry, when you're evaluating whether a trust and its assets are going to be property of the parties, divisible between them, you've got to look at the control of the trust, the purpose of establishing the trust, who the range of beneficiaries are, the source of the trust assets, the flow of the distributions out of the trust to the parties to the marriage, and also are there arrangements in place where controllers are acting as puppets of particular people? Have we got arrangements that appear to be a sham? So different cases have given more emphasis, and based on different factual scenarios, it's sort of drawn together that these are the things that the court should really consider. So let's have a look at how this judgment considered these factors. Looking at the source of the assets, this was a really huge consideration in this case. So in Kennan and Spry, if you're familiar with it, if you're not, go back and I've got a paper about it. It's quite a controversial case because it had some audacious facts, and also it was a renowned trust and tax barrister who was trying to protect his own family trusts, and it was held that the trusts could be completely looked through because they were the alter ego of the husband in that relationship. So it's quite a famous case. And the wife in this case, Caldwell and Caldwell, really tried to rely heavily on Kennan and Spry. Firstly, the judge actually said, look, Kennan and Spry had some very unique, audacious facts that we can't just apply here. And in fact, we can really contrast this scenario to Kennan and Spry. So they looked at the fact that the assets in the trust, obviously they've been restructured, and these trusts haven't been around since the 1900s, but they've been around for a long time, and the source of the assets in those trusts are from a four-generation family business set up from the 1900s, and they've grown and accumulated from that generational input into those businesses and the assets. It's the trust assets, I like this part, reflect the efforts of a long line of direct lineal descendants of the founder of the business, and in particular, Mr. K, the husband's father. So that was given a lot of weight, particularly the fact that the origin of the trust assets in this case do not reflect contributions made by the husband and the wife. The husband works in the business. He's been remunerated very well, I think, from his role in the business, through salary and that type of thing. And that has actually allowed the husband and wife to amass significant assets outside the trusts. Like I said, they've got I think 16 to 22 million of their own personal wealth. So contrasting that with Kennan and Spry, which really was assets that I think that husband in that case had put into the trust at the start of the marriage, there's a long line of evidence showing that these are businesses that the husband has only just really become the successor for. There's also, they set up the Sea Trust in the 1980s, and in the recitals, that the husband's father, Mr. K, when it was settled, he actually said the purpose is to ensure the sound financial provision is made for members of the family and the future operation and administration of the Caldwell family business. And then there's a further clause which says it's established for the exclusive benefit of the direct lineal descendants of Mr. K, and no person who is a direct lineal descendant shall be permitted to be a trustee or a beneficiary. So this was actually the variation that was inserted in 2020 or 2019 to 2022, but in alignment with those recitals from the 1980s. And it was doubly entrenched, so you can't actually amend it to remove that. So the purpose of the trust was really clear, and each of the trusts had something similar to this. I think it is also very helpful that that variation excluding non-lineal descendants was made by the husband's father, not by the husband himself. In Kennan and Spry, the husband in the Kennan and Spry factual scenario did try to make changes and even wind up and vest the trust, but that was all done by him after the relationship breakdown had happened, and the court said you can't rearrange the trusts and sort out the deck, rearrange the deck chairs after it's happened. So I really think the fact that this was done by the husband's father as part of his succession plan was helpful. Um, I think in terms of our testamentary trusts, this lends support to the origin of the assets of testamentary trusts coming from not someone who isn't the party to the relationship, and also excluding spouses from the beneficiary classes of the testamentary trusts when we're drafting them, so that there's no spouses included from the very beginning of the trust. Let's look at control now. So in this case, the judge highlighted the wife cannot point to a long history of the husband exercising control over the trusts. The trusts were not established or used by the husband during his marriage with the wife. It didn't benefit the husband, wife, and the children. Control did go and transfer to the husband after the relationship breakdown, but only as a result of Mr. K's death, the husband's father's death. They looked at Mr. K, the husband father's long reign of control, and they dismissed any notion that while Mr. K was in charge, that he was acting as a puppet of the husband. So the husband really was not in control until he inherited control through his father's succession plan. And as we know, that was all, he actually inherited it jointly with his two sons. Interestingly, they didn't really spend a lot of time thinking that the husband was only one of the three directors of the corporate trustees, and for B Proprietary Limited, he wasn't even a director at all. But I think that might have been because the husband sort of is the ultimate controller through his like super appointer power. They don't use the phrase super appointer. I've just coined it that to emphasize that even though there's three joint appointers, the husband can actually unilaterally dismiss his two sons as appointer, and they don't have reciprocal powers to him. So he still is kind of the ultimate controller. So that's the was the position. The judge commented on his I guess speculations and what weight to be given to what he thought was going to happen in the future with respect to control. So he did give weight to the wishes in Mr. K's will. This is from the judgment here. Such a recent restatement of intention must directly impact must directly impact upon the exercise by the trustees of their powers, as it confirms the narrow purpose of the trusts to only benefit the direct lineal descendants of Mr. K. So basically, he's saying this statement in the father's will must influence the decision making of the trustees of the trust about how they are going to exercise their discretion to benefit beneficiaries, plus the fact that the wife is not a beneficiary. In terms of this super appointer role, the judge shouldn't seem to worry about it too much. He said there's no evidence the husband is likely to actually use that power to remove his sons as appointors without providing any reason. And the husband has indicated that he's got no intention of doing so, and I accept that to be the case. He also acknowledges because of the, as we know, shareholders can change the directors, and the shareholders of the corporate trustees are the husband and his two sons, Mr. G and Mr. H. And the fact that the husband is named first in the register means he's the one who exercises the voting power of the A-class shares. And again, they've said, well, he could potentially pass a resolution to remove G and H as directors, but he's not indicated that he has any intention to do so. So we won't worry about that. The husband, I think, also had made some submissions, and I think there might have been like agreements, or he's referenced a side agreement that we don't really have information on. But the husband sort of submitted that he sees the purpose of the trust is to facilitate the intergenerational management of the business for the benefit of the future generations of the lineal descendants. And I find that it is only in pursuit of that purpose that the powers residing in the husband would be validly exercised. And then in separate reasons, this is a different paragraph in the judgment. I've just sort of put them together. So there was no evidence or suggestion by the wife that the husband has actually exercised any of these control roles in relation to the trust. Um, it seems like he was involved in a limited extent in updating the deed to include that superpower role, super appointer role. And they're saying there's no evidence of his intention to actually control the trust. And there's this side agreement that going forward, he might actually vary the trust to remove that super appointer power after the conclusion of these proceedings. Who knows if he not? But the judge, gave it emphasis. In terms of distributions, I think it was very helpful that the husband himself has never received any distributions from the trust. There's not a lot of information as to who did benefit from the trust, and it might be that all the benefit had gone to the husband's parents, and the timing of the relationship breakdown and control passing to the husband being around the same year, that they just were like, nope, we're not making any distributions. But a lot of weight was given to that. So we don't know who benefited from the trust and what they're doing with the income accumulated, but the husband nor the wife didn't receive any benefit from the trust. So that was given a lot of weight. In terms of these comments here where the judge was sort of saying, like, I accept the husband's submission that he is going to exercise any powers he had only to manage this intergenerational transfer of wealth for the benefit of future generations of the Caldwell family. The judge also said, well, this is the purpose of the trust, and knowing that the trustee has an obligation to give real and genuine consideration to the interests of all the potential beneficiaries, how can we distribute assets to someone who's expressly not a beneficiary of the trust? And they did give a lot of weight to the fact the wife was excluded as a beneficiary. So really interesting judgment. It's not a difficult judgment to read. It is a bit lengthy, but it's not a real slog. So I would encourage you to have a look. The lessons I've taken out of this is that control of the trust is still very important. A lot of emphasis was given to that, and the facts were very helpful in the husband's position. I think that he hadn't been in control for very long. The fact that, the source of the assets and the purpose of the assets were coming from previous generations was given a lot of emphasis, which this is not a testamentary trust case, but I do think that that lends support for how we set up our testamentary trust, with this real focus on testamentary trusts being for intergenerational wealth accumulation vehicles and benefiting multiple generations. And when we are, providing for our beneficiaries, that they are just custodians of that wealth during their lifetime, but also to set it up for future generations as well. I have to say, I have never really been one to document a purpose of the trust in the recitals. I've sort of stayed away from it because I've been worried that sometimes it might be detrimental depending on what the purpose is. I think when it comes to testamentary trusts, the purpose is pretty clear because it's part of the wealth transfer. So it's always fascinating to see the protection of discretionary trusts being challenged in the courts, and to see how the courts are applying these principles from other cases. I think this decision is really helpful to see how the importance of intergenerational wealth transfer is emphasized and the weight that is given to it, as well as the purpose of setting up the trust. And it gives me a little confidence in discretionary trusts and especially testamentary trusts as well. So I hope you found this video useful.